Welcome to the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca. I'm Deepa Taylor, and today we continue to explore critical topics in family and divorce law in Ontario, Canada. Today's episode is particularly significant: understanding the voice of the child in family law. When it comes to family law, one of the most sensitive and crucial aspects is ensuring that the voice of the child is heard and respected. Whether it's through a formal process in court or during private negotiations, understanding the child's perspective is essential for making decisions that truly align with their best interests. In this episode, we'll dive deep into what the voice of the child means, when and how it should be considered, the legal framework surrounding it, and the implications it has on custody arrangements, mediation, and overall family dynamics. So, let's get started by defining what we mean by the voice of the child. The voice of the child refers to the process by which a child's preferences, feelings, and opinions are gathered and considered during family law proceedings, particularly in cases involving custody and access disputes. In Ontario, as in many other jurisdictions, the law recognizes that children have the right to express their views on matters affecting them. However, how much weight these views carry often depends on the child's age, maturity, and the context in which their opinions are provided. One of the most common ways to formally capture a child's voice in legal proceedings is through a Voice of the Child report. This report is usually prepared by a professional, such as a social worker, psychologist, or a qualified legal practitioner. The report provides a summary of the child's views and is non-evaluative, meaning it doesn't include the professional's opinion on what should be done, but rather focuses on relaying the child's perspective. So, when should the voice of the child be considered? The answer is that it can be relevant at various stages of family law proceedings. Typically, the child's voice is considered during mediation, negotiations, or court proceedings when decisions about custody or access are being made. However, it's essential to understand that this isn't something that's automatically done in every case. A child's views may be sought before litigation begins, during the proceedings, or even later as part of a reassessment. The timing often depends on the specifics of the case and the readiness of the child to articulate their views. It's crucial for parents and legal professionals to carefully consider the timing of when to introduce the voice of the child. For instance, if a child is of sufficient age and maturity to express their views, their voice might be solicited early on in the process, potentially influencing negotiations, or even leading to a settlement that avoids court altogether. But it's also important to consider whether the child's involvement at a particular stage might be more stressful than beneficial. This decision requires a delicate balance and often the guidance of experienced legal counsel or mental health professionals. The preparation of the Voice of the Child report is a specialized task that should be handled by someone with appropriate training and experience. This could be a social worker, psychologist, or lawyer with specific expertise in child development and family dynamics. The individual preparing the report needs to have a deep understanding of child psychology, as children express themselves differently than adults. For younger children, this might involve more play-based interactions, while older children may be able to articulate their thoughts more clearly. One critical aspect of this process is ensuring that the child's voice is captured without undue influence from either parent. The professional involved must be skilled in interviewing children in a neutral and supportive environment, ensuring that the child's true feelings and preferences are conveyed without pressure or manipulation. The legal framework surrounding the voice of the child in Ontario is guided by several key pieces of legislation, including the Children's Law Reform Act and the Courts of Justice Act. Section 24 of the Children's Law Reform Act, for instance, explicitly states that a child's views and preferences, if they can be reasonably ascertained, should be taken into account when determining what's in their best interests. The Office of the Children's Lawyer, OCL, often plays a significant role here, particularly when a court orders an OCL investigation to ascertain and present the child's views. However, it's important to note that while the child's voice is considered, it is not determinative. This means that the court will weigh the child's preferences along with other factors, such as the child's age, maturity, and any evidence of undue influence. Understanding the impact of the voice of the child is crucial for anyone involved in family law proceedings. For many parents, Hearing their child's true feelings can be a powerful and sometimes emotional experience. It can significantly influence the direction of negotiations or the outcome of a case. In some situations, the child's input can help resolve disputes more quickly by providing clarity on what would make the child feel most comfortable and secure. For instance, if a child expresses a strong preference for a particular living arrangement that both parents can agree on, it might lead to a resolution that avoids further court intervention. However, it's equally important to recognize that the child's voice must be considered in context. A child's preferences might be influenced by many factors, including their relationship with each parent, their desire to avoid conflict, or even pressure from one parent. The ultimate goal of considering the voice of the child is to ensure that the resulting decisions truly serve the child's best interests, providing a stable and supportive environment for their development. What happens if one parent disagrees with the findings of a Voice of the Child report? While these reports are a valuable tool, they are not immune to scrutiny. Parents or their legal counsel can challenge the report if they believe it is flawed or if the child's views may have been improperly influenced. This could involve questioning the methods used by the professional who prepared the report, the context in which the child was interviewed, or any perceived biases in the report. Challenging a Voice of the Child report typically involves cross-examining the professional who prepared it, presenting alternative evidence, or providing the court with additional context that might explain the child's views in a different light. In conclusion, the voice of the child is a fundamental aspect of family law that ensures children are heard during one of the most challenging periods of their lives. While it is a powerful tool, it must be used carefully and thoughtfully to truly serve the child's best interests. Whether you're a parent, a legal professional, or someone interested in understanding family law better, recognizing the importance of the voice of the child and knowing how to approach it can make a significant difference in the outcome of family law cases. Thank you for joining me today on the Divorce Lawyers podcast. If you found this episode helpful, please share it with others who might benefit from this information. And if you have any questions or topics you'd like us to cover in future episodes, feel free to reach out. Until next time. I'm Deepa Taylor, reminding you that every voice, especially the voice of the child, matters.